Ladies and gentlemen, welcome to the People's Law School. It is an effort by the Alabama Association for Justice to bring to you the best lawyers in America. Kerri Riley's one of them. I will tell you, she's one of the best trial lawyers I know. She's been at it a long time, and she's real good. She's from here, Huntsville. She graduated from Lee High School. She was the valedictorian there, went on to Alabama where she got her chemical engineering degree, and then went on to law school and has been a general trial lawyer except for a short stint where you were the acting city attorney, I know that, and has been in all of our trial courts in representing people who are injured and hurt in various ways. I know she's been involved in several seven-figure jury verdicts and settlements, and I refer many people to her when I can't take the case. I'm not kidding. But she's a mother of three, grandmother of three, and of a very large poodle. And she is mighty busy because her boy is like 7, is that right? 9, growing before we know. But she's an excellent lawyer. And tonight she's going to talk to us about sex in the workplace. Kerri?
Well, thank you very much, Alan, for most of that introduction. I always think that this program ought to have a subtitle, Sex in the Workplace, Just Say No. So I've just now given you the very best piece of advice I can give anybody in a sex harassment situation, in addition to the behavior that's objectionable being severe enough and pervasive in a workplace if you're going to complain about sex harassment. It also has to be offensive and offensive to you, and the best way to prove that if you get in a situation like this is to just say no. So there you have it. And on that happy note, I think thanks a lot for having, no, not really. No, not really. All right, well, let's talk a minute about sex harassment lawsuits. First of all, I'd like to give the little family-friendly warning. Many of you have been here before, and I see some new faces also, so I will be starting from the ground up for everyone who hasn't heard this talk before, and for some of the folks at home who haven't heard it, although I bet some have. I do enjoy having some repeat faces. It makes me feel very comfortable to see you. But for those of you who've heard this before, and those who haven't, this topic is inherently offensive. The language and innuendo is inappropriate for young children, so if you're at home, keep that in mind. My son is at wrestling practice. I had to explain more than once why he could not come with me tonight. He's 9 years old, but anyway, I will be using interesting euphemisms for some of the language, because there's really no way to teach a class like this without letting you know what was said, but I don't really like to say that stuff. So there's my disclaimer at the outset. There are 2 main venues for bringing a sexual harassment claim should you find yourself so unfortunate in the workplace to be in that sort of situation. You can bring a traditional sex harassment claim pursuant to Title VII in the federal court system. And you can also bring we'll call it a pseudo-sex harassment claim. State of Alabama does not have a law against sex harassment per se, but you can bring a sex harassment claim in state court by the vehicle of different types of traditional torts, like invasion of privacy, negligent training, supervision, hiring or retention, outrage, which is just plain that's outrageous, and also assault and battery if there's touching involved. So you have 2 different venues that you can bring sexual harassment claims in, and I will talk a little bit about both of them. First, I'm going to talk about state law claims for just a minute. Now, everybody knows where county court is, right up here. Madison County Court at the Courthouse Square. If you bring a lawsuit in state court based upon a sex harassment situation in the workplace, First of all, you need to know some of the differences between bringing a claim in state court and bringing a claim in federal court. In state court, you have 2 years to bring your claim, which is a long time, because in federal court you only have 180 days or you're out of court. So sometimes cases get brought in state court because whoever it was waited too long to come to see their lawyer. You have 2 years in state court. However, in state court, unlike in federal court, you cannot recover your attorney's fees if you are successful. So if you are successful in state court in bringing one of these types of cases, you have to share the monies that you recover with your lawyer. In federal court, if you're successful, then your lawyer can petition the court to allow attorney's fees to be paid by the losing party. So it's to your advantage to go ahead and get on in to see that lawyer so that your claim can be brought in federal court as opposed to state court. But there are some times you cannot bring a case in federal court because there is no jurisdiction to bring that claim in federal court. If you're going to go to federal court, you got to have at least 15 employees. If you don't have 15 employees, you're in a small mom and pop employment situation. Then the only avenue you have is state court. Other than that, once you get into court, the proof is pretty much the same for either type of venue for a sexual harassment case. Now, how many of you think you know what sex harassment is? Anybody want to raise their hand? You know it when you see it? Who wants to volunteer? What is it?
Uninvited advancement sexually that is unwelcome.
An uninvited advancement that's unwelcome. That's a pretty good lay definition of sex harassment. And in an employment situation, what is the person supposed to do first if they are in a situation where someone has made an advance to them, a sexual comment, that is unwelcome and offensive? Ah, somebody was listening. Just say no. That's great. And after you tell this harasser no, and they keep on, what is the next thing that you should do?
Report it to your supervisor.
Report it to your supervisor. That's absolutely correct. And not only are these common sense things to do, but these are also the law. You've got to let the person harassing you know that it's unwelcome. And then generally speaking, unless this person has a history of which the employer, I heard it just a minute ago when I walked in from the last speaker, a history that the employer knew or should have known that this person had a propensity to be a sexual harasser, then you've got to let the employer know for the most part too. So you have to report it. And again, I just heard the other speaker give the advice to get it in writing. That's always good advice. Make your complaint in writing, because that way you don't have any question that there's proof. And this is also what the law requires, that the employer be notified. Good idea to do it in writing. After that, many employers, how many of you work for a fairly large employer with an employee handbook? Can I see a show of hands? Yeah, a lot of you. And in that employee handbook, I bet there is a sexual harassment policy. Everybody's nodding their head. Well, there's a reason why that sexual harassment policy is in that handbook, and again, it has something to do with the law. In federal court, at least, and in state court, this is we don't have anything corresponding to this, but in federal court, in a situation where there is sexual harassment, and it is sexual harassment not of a nature where some negative employment action is taken. Let me say that a different way. Sexual harassment where there is no tangible adverse employment action, just comments, no demotions, no firing, no assignment to the dungeon or wherever you don't want to be because you won't, do whatever the the harasser wants. Nothing like that, just comments that are really offensive and awful. Then, in that case, if there is a policy in that handbook, and it's a good policy that's enforced, designed to prevent and correct sexual harassment, and you don't use it, then you're out of court. Now, in case in federal court where there is tangible employment action, you don't have to worry about that defense. You don't have to worry about that policy. But where there's just comments, and just comments can be pretty darn bad, but where there's just comments and nothing bad happens to you in terms of your job or your position, then in federal court, if you don't use that policy, don't follow it, you can be out of court. So this is how the law has developed, and that's why those policies in there. Now, as a practical matter, we try a lot of cases on the policy because the policy has to be disseminated to everyone. And it's amazing how many times those books are tossed around, but there's been no signature that the new secretary got one, so she didn't get one. She didn't know the policy. But it has to be disseminated. It has to be something that can be easily followed. It can't be the only person that you report sex harassment to, the actual harasser. It has, or maybe the only person you can report it to is a man, and he doesn't, you know, he's as bad as the guy that's harassing you, or a woman, because we see some women on male sex harassment these days too, and I've tried some of those. But and then in that case, if your only person to report to would be a woman, and it was a guy trying to report to a woman, and she thought it was ha-ha funny that he was getting harassed, well, that's not a policy that's disseminated or easily used. It has to be one that is designed to prevent sex harassment and correct it. If it isn't a good policy, then it doesn't really matter if you used it. The federal courts will still allow a person to proceed to a jury verdict. So these are some things that the law has developed in certain ways, and then we see it played out in the workplace in the form of an employee handbook. But let's just say that there's a sex harassment situation at work. What should someone do? Does anybody know besides say no and report it in writing? Get no action. What's the next thing to do? Does anyone know? The comment was to file a police report. And you know, I had a case like that. I did. I had a case where a client reported and complained, and they moved the harasser, reported and complained, and they moved the harasser, reported and complained, and you know, they just kept slapping the harasser on the wrist several times. And finally, the situation was so extreme that this employee stormed out of the workplace and went down and filed a police report. Yeah, I did have that case, and that case did resolve. So, you know, it was a good plan. That was a really good plan. I'm glad she thought of that. That's not usually what I advise people to do, but worked out well in that case. But what you have to do if you get no satisfaction from your employer is you must, within 180 days of the adverse employment action meaning something bad that happened to you at the workplace, either a reassignment, a termination, a demotion, or an act of sexual harassment. Within 180 days of that adverse employment action, you've got to go down to the EEOC in Birmingham, Alabama, and file a charge. In all Title VII cases, and sex harassment cases are Title VII cases, they're brought under Title VII in federal court. In all sex harassment cases, a charge of discrimination must be filed. In all Title VII cases, a charge of discrimination must be filed with the EEOC down in Birmingham. If you fail to do that, game over, out of court. And it's got to be done within 180 days. Now, when I speak of Title VII, it's broader, of course, than sex harassment. It includes other types of employment-related cases that I also handle. Americans with Disabilities Act begin with a charge of discrimination with the EEOC in Birmingham. Age discrimination, race discrimination, national origin. We're seeing some religious discrimination cases now. reverse race discrimination, reverse gender discrimination, sex discrimination cases. We're seeing some reverse cases now. So all those types of cases arise under Title VII, and they have to start with the charge before the EEOC down in Birmingham. Now, after that charge is filed, an investigator is assigned, and they are some good, some not so. But in any case, the EEOC has to have an opportunity to investigate your charge and try to conciliate your charge with your employer before you receive what's called a right to sue in federal court. If you don't go through that charge process and allow the EEOC to do their thing, after which they will either successfully resolve your charge, which rarely happens, but every now and then, or the EEOC occasionally will take over your charge and prosecute it for you. Then you can't hire your own lawyer. But after that process, then the EEOC will generally issue what's called a notice of right to sue. It means now you have permission to go to federal court. So you take your claim to federal court, and you must do that within 90 days. Again, 90 days, game over if you have not filed your lawsuit in federal court. I see a question. I will take questions as we go along. I kind of enjoy that, especially if they're on point. The question was, if the EEOC takes over the case, does it go to the Justice Department or does it stay within the EEOC? The EEOC has its own trial lawyers. Now, they fall generally, I think, all U.S. attorneys fall generally under the Justice Department one way or the other, I think. But I could be wrong about that. I have to say, I'll have to ask the lawyer that works for me, whose husband is a U.S. attorney, if they ultimately fall under that umbrella. But I do know the EEOC have their own trial lawyers who are very experienced. But mostly they take big class action type of cases. Very few where there's just one or two or three individuals who've been harassed. Is age discrimination still 40? And the answer is, well, kind of, sort of. You're an older individual when you're 40, which is a lot younger than it used to be. So good luck for all you 40-year-olds trying to prove age discrimination, okay? But yes, I don't think anything has changed about that except the realities of our aging workforce and the likelihood of success at 40. Anybody else? Okay. Well, back to lawsuits. So let's say that there is a sexual harassment situation. The EEOC charge was filed. The EEOC has issued their notice of right to sue, and you're going to federal court. You've hired your lawyer. Well, you bring your Title VII claim, but you also get, if you're going into federal court, you also get to bring along your state of Alabama claims as well into your federal lawsuit. So another really good reason to pursue the federal avenue whenever you're bringing sex harassment cases, because you can bring your Alabama claims for invasion of privacy, outrage, assault and battery, which of course is just touching or fear of touching, in this case in an offensive way. You can bring all those claims all in your federal case. And then if, you know, something happens, you find out, oops, they only had 14 employees and for the requisite number of weeks, well, you haven't lost any of your claims. They're still there. So there's some little bits of differences in the standards of proof, the instructions that might be given to the jury in the federal Title VII claims versus the state law invasion of privacy claims. Particularly that one is a little bit different. And sometimes juries, for whatever reason, think the facts fit one type of claim just a little bit different than the other. So most lawyers bring several different types of claims. And then at the end of the day, after the case is presented to the jury, a jury will hopefully pick one and maybe more than one of those claims to find that the facts fit into where your plaintiff can prevail. There is a difference in sex harassment, whether or not it is a supervisor who is doing the harassing or a co-worker who is doing the harassing. All the time, if it is a coworker who is doing the harassing in the workplace, it is imperative that you put the employer on notice. They have to have actual notice that this coworker level person is doing the harassing. If it's supervisory, it's a little bit different. Employers are generally speaking responsible for their supervisors' actions in a way that they're not necessarily responsible for your coworkers' actions, because they are presumed to be on a level with you. You're presumed to have a better ability to say no to them than a supervisor who is in your chain of command, so to speak, who holds the key to your raise or your employment environment. Now, everybody always wants to know what you can get if you're harassed, and the answer is not enough to make it worthwhile, believe me. These cases are, by the time someone comes into your office, they have, generally speaking, suffered a lot. Very few people, and I'm not saying all people, but very few people who make the effort to come into a lawyer's office and complain about their workplace. Someone is discriminating against them based on their race, for example, or based on their sex, or someone is saying, ugly, sexually inappropriate comments to them persistently in the workplace. Very, very few of those people have not suffered trauma at that point when they come in. It begins to affect their families. It begins to affect their demeanor off of work. They get up every morning with a sense of dread that they have to go into the job. And I know some people feel that sense of dread every day, no matter what. But there's an extra level when someone is going to be bullying you on a daily basis in the workplace. And this is actually just, and I say just, but it is actually a form of bullying. It's another way to look at bullying. Sex harassment is just not about sex. Never has been. It's a way of picking on somebody. And because a person is in a position of power and can. And that is why the law has found that this type of behavior cannot be tolerated, and why it's against the law. So, back to damages. What can you get? Well, if you prevail, you get your back pay if you've been terminated. And many times people are terminated. Sometimes they quit. I never recommend that anybody quit unless they have a thorough evaluation of their case by a competent lawyer in this field before they do the quitting, because it is awfully hard to prove what's called constructive discharge. I quit because it was so intolerable that nobody would have been expected to have stayed. Now, if there is touching, and when I say offensive touching, I don't mean rubbing on the shoulder. I mean, downright offensive touching in the private area kind of touching. Then you can quit. It's okay if you can prove it and still maintain your claim. Otherwise, constructive discharge cases, I quit because it was so bad that nobody should have been able to tolerate this, are very, very hard to prove. But if you can prove it, you can get your back pay if you've been terminated. You can get front pay, which is the money that you would have made but for quitting. You can get sometimes a reinstatement, but that is a remedy that is rarely granted. In most cases, the judges figure it was so awful you had to quit. Why would you ever want to go back? And in cases where the employer has terminated a person, also, which is sometimes one of the adverse employment actions, they just fire you for complaining about it. The judges think, well, it was so awful, the kind of people that would fire somebody for complaining about this, why would I put somebody back to work in that situation? But I do see reinstatement in government situations sometimes, where there are merit systems, tenured situations, then the judges sometimes reinstate. But you can't get reinstatement as a remedy. Attorney's fees, and then compensatory damages, which are capped. Only $50,000 of stress and distress type of damages, pain and suffering. For employers who have 100 employees, up to $100,000 for employers who have up to 200 employees, up to $200,000 for employers that have up to 500 employees, and over 500, the max amount of pain and suffering type of compensatory damages is $300,000. So, which isn't what it used to be. So nobody's getting rich off these cases. If you're going to bring a case like this, it's usually a combination of compensatory for, you know, being out of work. Most of these people are fired, and some sense of righting the wrong. You know, doing it so that nobody else has to go through this again. State claims are also capped, but the caps are just a little bit different, and I'm not gonna go through that right now. Now, last year we talked about a particular case. I don't know if any of you who were here last year remember it, but it was a case of a lady who had been in the Merchant Marines. Who was here last year remembers that? You remember that one. It was bad. Okay, well, the lady who'd been the Merchant Marine, this is one of the most extreme cases that I've run across in a long time, and we didn't know what was going to happen last year, so I'll review the facts with you, and then I'll let you know what has happened. This is Reeves versus Robinson Worldwide, and it was up before the 11th Circuit Court of Appeals last year when we were here. Now, do you all have some understanding of the court system beyond county court up here on the courthouse square and the federal courthouse, which is on Home Street across the street from my office? Beyond that, if you do not receive satisfaction in either one of those places, or if the other side doesn't receive satisfaction, they thought they should win and you did, which is a happy day, either side can appeal. Of course, we understand the Alabama Supreme Court is the ultimate appeal from county court, and in federal court, we first go to the 11th Circuit. We're in the 11th Circuit, which is in Atlanta, based in Atlanta, and the appeals judges are there. And then occasionally, when there are disputes in the law among the various circuits throughout the United States, cases appeal all the way to the Supreme Court. So in this case, we had a case that was before the 11th Circuit. The plaintiff was not a shrinking violet. She had been in the Merchant Marines. She had heard and seen some things, and she had been in a predominantly male environment most of her career. She worked with 6 co-workers in her employment after the Merchant Marines, and she could hear the co-workers on the phone and in conversation with each other, and she could hear the office radio. And her co-workers' language was, shall we say, unusually vulgar, even compared to the Merchant Marines. It was not necessarily gender specific, but an awful lot of it was gender specific and negative to the female gender. It was never directed directly at the plaintiff, though. Never. Not one time. You, whatever, or nothing directed directly at her. And I kind of have, I wonder why. You know, maybe she was pretty tough. I don't know. But, you know, I just don't know. That's my question. But these male co-workers referred to other females in the workplace and females that they spoke to on the phone routinely as witch, not quite, effing witch, and effing lady of the evening, not quite, family friendly and all that. And sometimes they'd slam down the phone and yell these things at the slammed down phone. They enjoyed a particularly crude morning radio show that frequently talked in derogatory terms about ladies' anatomy, and sometimes in positive terms about ladies' anatomy on a regular basis, and that was blasted through the office. And they sang songs about women that were generally speaking, derogatory. So anyway, she did what you're supposed to do. She said, look, guys, this is even too much for me. Please stop. They did not stop. And she complained a number of times. There was I would even say an excessive number of complaints. I got the sense this lady really did not want to go there. She just wanted it handled. Nothing changed. She went to her supervisor. You know, ha, ha, ha. I mean, he participated in it all. He wasn't going to do anything. Eventually, she, as a good former merchant marine person would do, she went up the chain of command and complained. Nobody did anything, and eventually she resigned. Well, the district court, the first level court, the court that would be akin to the courthouse on Home Street across from my office, and there's one in Birmingham and one in Florence, and different places. There used to be one in Jasper. I don't know if we still hold court in Jasper, but anyway, the district court threw the case out of court at the stage called summary judgment, which is a delightful stage in a plaintiff's case life, where you get to present your entire case on paper to the judge, and then the judge decides if you're going to get to present that case to the jury, or if you have not proved up your facts well enough under the law that the judge believes that a jury might award a verdict in your favor, then they'll just pitch it out of court. And this is usually months into the case, and lots of hours spent, and lots of time spent, and lots of money spent for the plaintiff's lawyer, and lots of drama and trauma for the plaintiff. So anyway, at this delightful stage of the case, the district court threw that case out and said that the offensive conduct was not motivated by the plaintiff's sex, which is a necessary thing for sex harassment. The conduct, the offensive language or touching or whatever it is, has to be motivated by sex, was not motivated by her sex because it wasn't directed at her in particular. It was just directed at the rest of us. The district court said that the language was used and the radio program was played in the presence of all the employees. Of course, this was the only female employee. And so both men and women were subjected to this, and the plaintiff was not singled out, and that was it. Under the law, threw the case out. At any rate, the 11th Circuit looked at that decision and said, wait, this is a hostile work environment case. The plaintiff was exposed to disadvantageous terms or conditions of employment to which members of the other sex, I love that, members of the other sex, how many are there? 2, I think, but I don't know. They were not exposed to this disadvantageous terms and conditions. The Court of Appeals emphasized that the courts have to look at the evidence cumulatively and in the totality of the circumstances, which basically means each one of these cases is fact-specific. They're all different, and you kind of never know how the court's going to rule on your particular case. Makes it very exciting for a plaintiff's lawyer. The courts have to look at the evidence cumulatively and the totality of the circumstances, and either severity or pervasiveness will be enough. So it's an or, and that's sometimes very important. Was it severe? Or if it wasn't very severe, was it pervasive? Did it happen all the time? Either way, in a sexually hostile environment case, you can get to the jury and present your case. And the court drew a distinction between, I love this, making a comment like, son of a bee, they lost that truck, which is not gender specific. Or no reference to gender. They said that made no reference to gender, which I thought was interesting. And calling a female coworker a B, which is gender specific. So they said there's the distinction there. Evidence that coworkers aimed their insults at the protected group, in this case females, may give rise to an inference of intent to discriminate on the basis of sex, even when the insults are not directed at that particular employee. The employer said, well, you know, plaintiff's coworkers, they all acted like this before she got here. So, you know, we didn't change anything. Why is it sex harassment now that she's here? But the 11th Circuit said, no. Once she got here and complained, you had to change. So they reversed summary judgment and sent the case back for trial. And that case did not go to the United States Supreme Court at that point in time. So that is the law today. Now that case has gone back for a trial. And I do not know if they actually have tried that case or if 11th Circuit having made their pronouncement on the facts, someone wisely paid some money and settled that case. But anyway, that's where that case from last year ended up as far as we know today. If it's tried, we may hear from it again. I have an interesting Alabama case to bring to you this year, Ex parte Carlisle. And this sort of illustrates some of the differences between state court and federal court, but it also illustrates that, you know, we're all human beings. We all have our biases. I mean, we all have biases and prejudices. The idea when you go to court is whether or not you can set those aside and be fair. But those of us who are women, I mean, we're women, we can't change that. And those of us out here who are men, you know, you've got those biases. You're more likely to understand boys will be boys type of behavior, for example, as a man. And women are more likely to have a woman's point of view. Just is how it is. And you'll understand why I'm bringing this up when you hear how the judges ruled on this particular case. In this case, Ex parte Carlisle, the plaintiff sued in state court for assault and battery, invasion of privacy, outrage, and negligent supervision or retention. And those are those Alabama torts that stand in for sex harassment, since we don't have a specific law against sex harassment in the state of Alabama. I don't know why we sued in state court here. If it was a small company, didn't meet the 15-employee threshold, or if the plaintiff didn't get around to go see their lawyer for 180 days. I don't know why we're in state court, but we're in state court. The supervisor inappropriately touched the plaintiff, made sexually suggestive and offensive remarks, flashed her, let's just leave it at that, made inappropriate sexual references in her presence. During her deposition, now some of you may or may not know what a deposition is, but in the course of the march to trial, when you're getting your case ready for trial, you have to know what the other witnesses are going to say. And in federal court for sure, and in state court most of the time, you have to be in a position to present your entire case to the judge on paper before the judge will decide whether you're going to get to go and present your case to the jury or not. So in order to do that, if you want to find out what a witness is going to say, and they're not necessarily a friendly witness, they won't come into your office and sit down and give you a statement you can write down under oath and they can sign, then you have to do what's called take a deposition. And that's where it's a legal process. The person is commanded to appear, court reporter is there, and you get to formally ask them questions. They get to ask you they don't get to ask you questions. As a lawyer, you get to ask them questions and they have to answer you. A lot of people think they get to ask the lawyer questions, but they don't. So during the deposition of the plaintiff, because defense counsel gets to ask the plaintiff questions and plaintiff's counsel gets to ask the harasser questions, for example. In this case, during the deposition, opposing counsel asked the plaintiff questions about her sexual history. And her lawyer says, oh no, we're not going there. So they stop the deposition and they go ask the judge, does she have to answer these sorts of questions? And filed what's called a motion for protective order, which means, does she have to answer these questions, judge? Or, would you please prevent the opposing counsel from asking these kinds of questions? They're not relevant to this case. What's her prior sexual history have to do with anything? Well, the trial court said no, she has to answer. So the case stopped right there. They certified the question and took it to the Alabama Supreme Court. Does a woman have to answer questions in the state of Alabama about her prior sexual history when she's brought assault and battery, invasion of privacy, outrage, negligent supervision type of case, basically a state court sex harassment case. And our Supreme Court said, well, it's not irrelevant. It's a sexual harassment case. It's not a car wreck. And how her sexual history is relevant to show the degree of offensiveness to her. Okay. And Chief Justice Sue Bell Cobb dissented from this decision. And she says, this evidence is not calculated to lead to the discovery of anything relevant. They just want to embarrass her and harass her, and you guys are just plain wrong. So, at any rate, I think she was the only female justice on the court at the time. Yep.
180 days is from when? From the last occurrence and until when? Is it till they file in the court or till they see the attorney or what point?
Okay. The question is, how do you count the 180 days? From what point in time? From the last occurrence till you get in to see your lawyer, from what period of time? Now, as a good lawyer, I'll tell you, count it from the earliest possible date, because none of us like to have interesting legal questions. And the way you have interesting legal questions and make new law is when somebody messes up or is late and you're trying to squeak it in. So count it from the earliest possible date. That being said, if there is a history of sex harassment, daily comments, regular touching that goes on, not discrete incidents. One happened this month and nothing happened for 6 months, but just kind of a regular pattern of conduct, then you can count from the last act, 180 days. But I don't advise it. Sooner rather than later.
Too long, it seems like the answer would be, or the counter to that is, well, you put up with it this long, how do you say that this is offensive now?
The comment is, if you wait too long, then it seems like that the argument would be, well, you put up with it this long, it couldn't have possibly been offensive, or you'd have done something sooner. And with all due respect, the comment is coming from a male person, because my bet is that the women in the room would understand that most people who've been harassed put up with it, as you say, for a long period of time, because they try to stop it, it doesn't stop, and they realize that they're really going to have to take a stand, and very likely their job will be in jeopardy from then on. The reality is, most of the time, their job is in jeopardy. If they don't get fired, their workplace is made so intolerable once they complain. And the question is, if they put up with it for a while, when does the 180 days start? Well, the 180 days starts with the first act, but it can toll or start again with each new act, provided that you've got a pattern, provided that it's a continuing and regular occurrence. And if it is, you can file 180 days from the last act and go all the way back and pick up the first one. But I don't advise it, again. But often that is how it works, because many times it takes months or even years for someone to finally file. Because that is going to start a process of notification of the employer formally that a claim is pending, and those, in most cases, end with the person leaving their employment one way or the other. And although we've been talking about women, and your question was posed as a woman, in fact, don't forget, we're seeing, as more women rise through the ranks, and more of the young guys come into the workplace, we are seeing female on male. We are seeing it. And the question was, how would a woman know, or how would a person know that they had only had 180 days and their clock was ticking? And the answer is, I don't know, they might not. It is a good idea to seek out an employment consultation with a qualified attorney. Really it is. And I do this all the time to advise people, because frequently they don't know their rights. I've never had anybody come in and pay for an hour of my time just to find out their rights who was ever sorry. Never one time. Those are some of the most satisfied people that I have. If I never see them again, or if they have a great case, they're the ones that come back 2 or 3 years later. Somebody got in a car wreck and they want me to represent them. So I'm always willing to do that, and I'm sure others are too.
Back to the 180 days.
Yes.
If the company has a policy that requires you to go through the several steps, don't you have to complete those before the 180 days would start?
That is an excellent question. The question for anybody who did not hear it is, if the company has a policy that you have to go through several steps, a grievance type process, I assume you're speaking about, don't you have to do that policy before you file with the EEOC? Who has an idea what that answer would be? Who has an idea? I don't know. You know the answer back here. All right. Lady in the pink. No. No. Do not wait. Do not wait. If you, I always call it dip-dorking around, but if you're dip-dorking around with the company and you let your 180 days run, it has run. It has run. And there have been a time or two when I thought that was the express purpose of all that grieving and process, was to run people's time out. So you do not wait. You need to go ahead and do it, but you need to participate in it. Absolutely. Shows your good faith.
But you said earlier.
But do not let your 180 days run. Yes.
You said earlier that if the company had a policy and you didn't follow that, you didn't have a case.
If the company has a sex harassment policy whereby you need to report sex harassment, you must do that. You must do that. Or potentially, if there has been only talk and no tangible employment action, you will not have a case. That is correct. It's always a good idea to follow the company policy if it's a good faith policy. That won't hurt you any. In fact, even if you do still have a case, how are you going to explain to the jury that you ignored the policy that the company's going to say was designed to help you and prevent this and correct it and do the right thing? So it's always a good idea to follow that company policy. But don't wait to see the lawyer, because if you mess around with your time, it's apples and oranges. Your 180 days will run, and there you go. And I don't like figuring out how to save it, which occasionally you can do if in sex harassment cases only, not any other kind. Yes, sir.
Just a comment to the how would you know question. The federal posters that you're required to post, I believe, has the 180 days on it, and it tells you where you go to do that.
And the comment was the federal posters in the workplace, the ones that are all supposed to be there and not buried on the bottom of the bulletin board below free puppies and everything else that's up there, okay? They say you have 180 days and tell you what to do. But I see frequently those posters are buried on the bottom. In one case, I don't know why, whatever possessed me to ask the question, because they kept saying, well, you know, the poster was there, the poster was there, the poster was there. The harasser was a young Hispanic male who spoke very limited English, and he was very short of stature. And the poster was posted up on top of the refrigerator in English, okay? So, you know, anyway, yes. Didn't I work on an oil rig? What does this have to do with the price of beef in China? Is this a deposition? Good question. Yes, I worked on.
So didn't you work on an oil rig?
Didn't I work on an oil rig to put myself through college? Yes.
She pleads the fifth, I think.
I didn't spend the night on the rigs, no, but I did go out with the helicopter pilots who were all Vietnam vets and really crazy, and fly out to the rigs and take gas samples and do all that when I was 22 years old. Anything else you guys want to know about me? Okay. Okay, anybody, any other questions?
In state court, if the plaintiff can be questioned about their sexual history, can the defendant also be questioned? And so as to show a pattern of harassment?
The question is, if the plaintiff can be questioned about their sexual history, can the defendant be questioned about their history to show a pattern of harassment? Absolutely. And that would be true for both state court and federal court. And every lawyer who brings these types of cases does that. One of the first depositions you take is of the defendant. And yes, you definitely want to show the history. The defendants not infrequently lie about it, but that's fine too. You get them in a lie and you prove it a different way. You also want to show that the company knew or should have known of this history. And if they'd done just a little bit of investigation, you know, they would have known that it's out there. So absolutely. Okay, any other, one more.
If you do go to the EEOC, say Jane Doe has one going, a case going, and she goes to EEOC, would it be wise to advise her employer that she'd go to the EEOC, or just keep that under her hat?
Okay, the question is, if Jane Doe goes to the EEOC, would it be wise to advise her company that she has gone to the EEOC, or should she keep that under her hat?
For one thing, you may find out that you don't have a case. And then, boy, buddy, do you really not want to be in a position of having threatened your employer with going to your lawyer, because they might decide they can do without your services. And I see that sometimes. You know, Alabama is an employment at will state. And we have a lot of transplants here from other states in the country that are right-to-work states. In a right-to-work state, you have the right to have a job unless you do something wrong to lose it. In an employment at will state, you can be fired for any reason at all. Good reason, bad reason, no reason. Because you have blonde hair, because you have blue eyes, because you don't have blonde hair, because you don't have blue eyes. The only reason that you cannot be fired is a federally or state protected reason. You can't be fired because of your sex. You can't be fired because of your age. You can't be fired because of your race. You can't be fired because of your national origin or your religion or your disability. You can't be fired for those reasons if you can prove it. Other than that, you can be fired. And this is very, very hard for people to grasp. Very hard. I have had more than one local lawyer call me. Their sister's been fired. Their nephew's been fired. And they always start the conversation. Now, I know this is an employment at will state, and I know you can be fired for any reason, good reason, bad reason, no reason, wrong reason, but. You know, it's hard for even employers, even lawyers who do not do this on a regular basis, when faced with a personal situation, to understand that, yeah, they really can fire you. So I see a lot of people in my office who are transplants from right-to-work states, and they come in all huffing and puffing, thinking they've got all these rights. And they go out with their tail tucked between their legs, because I say, look, and they're like, what do I do? I said, go back and tell your lawyer, tell your employer you lost your mind, apologize abjectly, and you need to work, okay? So don't be threatening your lawyer at the outset. That's your question. Now, the other question, the question you did ask was, should you tell your employer that you've gone to the EEOC? I don't think you should tell them that either, but they're going to find out. Because within probably a month of you filing that charge, the employer will get notice of that charge. So then they're going to know. Okay, 1 minute. Oh my goodness, I've gone so gone over my time. It's gone really, really great. Okay, well, a couple new updated cases. U.S. Supreme Court case, very important, just came out. I mean, just about a week ago. A lady filed a sex discrimination charge with the EEOC, and they fired her fiance. And guess what? Well, lower courts threw it out. Eventually, it makes its way to the United States Supreme Court, and the United States Supreme Court says, even though he didn't do anything, he's not a protected class, he engaged in no protected behavior, he can sue because their employer retaliated against her by firing him. So he has a lawsuit. Very interesting. I'd seen this before with husbands, but never with fiance.
Thank you so much for having me.